Hello and welcome to Fire Away, Rudner Law's online Q&A show focused on the employment law issues that matter to you. My name is Stuart Rudner. I'm an employment lawyer and mediator, and I'll be your host of Fire Away today for season 2, episode 7. And we're changing things up a little bit today. Normally, we have a guest. We focus on a particular issue and we go through a bunch of topics or questions on that particular issue. But what often happens is we have questions that come in that are entirely unrelated to that topic, or we get questions throughout the month that are unrelated to a particular topic. So today we're going to clear the decks and go through a bunch of the questions that we've received. You may have also noticed that over the last week or so on our social media channels, we've been asking for questions. So we've got a whole bunch that we'll do our best to get through. Today, it's just me and Rob, my producer, is going to be feeding me the questions as we go. We'll get through as many as we can, anything employment law related, and might as well just get right to it. So, Rob, why don't you take us to the first one?
Sure. All right. So, Stuart, question number one is it okay to temporarily lay off full-time employees, or does it expose an employer to constructive dismissal claims?
Great. Thanks, Rob. And I should mention, we're not putting anyone's name here. We're kind of assuming that if you write into us and say, if I do something, can I be fired? You probably don't want everyone to know who you are and where you work. So we're keeping everything anonymous today. But this is a great question. It hits upon one of the most common misconceptions that we deal with. Everyone assumes that every new hire has a built-in probation period. And the legal reality is exactly the opposite. There is no automatic right to either have a probationary period or to lay employees off. And that's the other assumption that people make, is that you can lay people off short term. There's a slowdown, there's a seasonal slowdown in work, there is some other reason why things are slowed down, but you know it's only temporary. A lot of employers assume they can just tell the employee, don't come in next week. And the reality is that legally there is no automatic right to temporarily lay off employees. And it does, in fact, constitute constructive dismissal, which is exactly what our viewer asked. So, taking a quick step back, what is constructive dismissal? Constructive dismissal is a substantial change to a fundamental term of the employment relationship. And really, what could be more fundamental than providing the employee with work for pay? So, when you tell the employee, you can't come into work, we're not going to pay you, you are fundamentally changing the agreement, even if it's just temporary. And that is a breach of contract, or in this context, constructive dismissal. The only time an employer is allowed to do this is if they have a contractual right, and that can be explicit or it can be implied. Implied would be situations like, for example, the construction industry. We all take it for granted that at certain times of year, things are slow. Construction workers might be told to stay home for a while. It would be pretty easy for most employers to argue that it was implied. Everyone knew that this was a possibility. In most cases, if you're an employer, you're going to want to put that right in the contract so it is clear and explicit. The reason there's a lot of confusion is because if you look at our employment standards legislation, including the Act in Ontario, it sets out the limits for temporary layoffs. And it basically sets out how long you can lay someone off for before it becomes a termination. So people see that and assume, okay, well, I'm allowed to temporarily lay someone off. And the reality is, this is quite misleading. It sets out the limits for what you can do if you have the right. But if you're an employer and you want to have the right to lay people off temporarily, now and again, or if it happens one day in the future, it's got to be in the contract. Never assume that you have the right. And if you're an employee, I've often, come across people who were temporarily laid off and just assumed that they had no rights, when in fact they could have filed a claim at that point and then never did anything because they didn't know the rights, they didn't see an employment lawyer. One of the things that's interesting, I mentioned the outset probationary periods. That's the other most common misconception or assumption. Everyone assumes that every employee has a probationary period built into their contract, which is also not the case, even though if you look at the employment standards legislation, there is provision that in the first 90 days in Ontario, first 90 days of employment, you can be let go without notice and without cause. That's only if the contract confirms this. So again, don't assume. I've mentioned this before. I'm the director of a course called HR Law for HR Professionals. One of the things that I really try to drill into everyone during that course is that there are so many legal regimes that govern the employment relationship. We're talking about employment standards, we're talking about human rights, workplace safety, occupational health and safety, we're talking about privacy laws, common laws, I've run out of fingers, labor laws. There are so many different regimes. You need to be aware of everything. So, for example, if you're an employer, and I've seen this happen to people, where an employer wonders, do I have the right to lay someone off temporarily? Things are going to be slow for the month of August, for example. And they'll look up the Employment Standards Act online and they'll see, oh yeah, it looks like I do have the right up to 13 weeks. And in many cases, they will even call the Ministry of Labor and double check that. And they will be told, yes, under the Employment Standards Act, you have the right to temporarily lay people off. The problem is that they don't look into the other laws, such as the common law, the law of constructive dismissal, and they end up making mistakes. And I've seen this happen. We had a client a number of years ago now who called the ministry and they were told, yes, you can lay someone off. They laid off a 10-year employee for a period of about 17 weeks. Ultimately, were sued for constructive dismissal and found themselves on the hook for a significant payout, in addition, of course, to the legal fees, all of which could have been avoided with probably a 5-minute call to an employment lawyer. So to come back to the question, can you temporarily lay employees off? Maybe, but only if there is either an implied right based upon the industry or the company, or even better, an explicit right built into the contract which says we have the right to lay you off in accordance with the applicable employment standards legislation. Otherwise, it's a constructive dismissal. All right, Rob, what do we have next?
All right, so the next question is related to employment contracts, and it reads, if I am asked to sign an employment contract and refuse, can the company refuse to hire me?
All right, well, thanks for that question. It's a really great question, and I wish I could give you a simple answer. The simple answer is maybe. But here's why I say that. If the company did things the right way, then there is no agreement in place, and they have every right to choose not to hire you. If the company did what is more common, which is to say you had an interview or perhaps a series of interviews, you discussed certain terms, and you agreed upon a start date, then you've effectively been hired. And once you've effectively been hired, you have a contract, and they can't refuse to go through with that. And this takes me back 25 years now to my first year contracts prof in law school. He used to explain that a contract is made up of an offer and an acceptance. So if there has been an offer of employment, and what that means is not just discussion of terms. It's normal that you go through the interview process, you're going to talk about things like the title, the duties, the reporting relationships. You're going to talk about compensation. You're going to talk about things like vacation. You may talk about things like, can you work from home, or will there be a car provided, or will you get a cell phone or a laptop? You can discuss all those terms without having a contract. But once you get to the point where you have agreed upon all those terms, where you get to the point where the company confirms that, yes, you've been hired, you'll be starting on a certain date, you now have a contract. And once the contract is in place, neither party can simply cancel it. And I should add, I'll digress really briefly, once you have that contract in place, you also can't replace it with a new contract. And this is where the vast majority of employers, including multinational companies, get it wrong. Because what they will do is they will have the person in for an interview and they will make an offer and the person will accept. And when the person shows up for their first day of work, they'll present them with a formal agreement. At that point, they already had a verbal agreement. Otherwise, why would they be there? They wouldn't be there for their first day of work unless they'd agreed to take the job. So to have them sign a new contract now is not going to be enforceable unless they get some sort of new benefit or new payment in exchange for the new deal. So coming back to your question, can they refuse to hire you? They can refuse to hire you if they haven't already hired you. Again, if you discuss certain terms and then they said, and this is what we coach our employer clients to do, you've found your candidate, you found the one you want, you've agreed notionally on certain terms, you then say to the person, we'd love to hire you. All of the terms and conditions are laid out in a written contract, and you either physically say, here it is, or you say, we're going to email it to you. We want you to review that contract, get legal advice if you choose. If you accept, sign it. Once you've signed it, then we have a binding agreement. But you have not been hired until that happens. If they did it that way, and they've now presented the agreement, and you, for whatever reason, don't want to sign it, then they are perfectly within their rights to say, well, then you don't have a job. And this is where we often help people out, where we will do the negotiating either directly for them, working with the company, or in the background, we'll guide them as to here are the terms that are of concern, here are the things that we think can be improved, and here's how we think you can improve them based upon our experience dealing with other contracts in similar industries with similar companies or maybe with the same company. Here's where we think you may be able to negotiate a better deal. And then either you will go back directly or we'll deal with the company directly and try to negotiate a better deal. And at some point, you'll reach the point where you say, you know what, we're not making any more progress. This is the best deal I can get. And either you take it or leave it. And at that point, if you choose to leave it, then the company is within their rights to say, well, then you don't have a job. So at the end of the day, what this comes down to is there already an agreement in place? If there is, then the company can't just refuse to go ahead. But if there's been no agreement to date and now they've presented you with one, if you don't accept it, then you don't have acceptance. You have an offer, but you don't have acceptance, therefore you don't have a contract. If you already have a contract, then you've got a job, and if they refuse to allow you to come to work, then you most definitely should go see an employment lawyer. All right, Rob, what do we have next?
All right, so I'm actually personally curious about this one because the concept of working an 8-hour day for most people is not the case anymore. We usually work anywhere from 12 to 14 hours a day. So, so the question is, what are your thoughts about the 4-day work week? Are there any legal implications for doing so?
And I'll remind you, Rob, that you're in the U.S., which has very different employment laws, so none of my comments apply to your situation. But it's a great question. We're seeing a lot more different employment relationships. The days of 9 to 5, as you said, Rob, are long gone for most of us. But we see a lot more part-time work. We see a lot more contract work. We see a lot more short-term work. And the reality is, even though the standard work week is still sort of a 35 or 37 and a half, or maybe a 40-hour work week, we see a lot of other people who have part-time arrangements. And of course, there's nothing legally wrong with that. There's nothing legally wrong with a 4-day work week. What I see, though, and what we often see, are the issues that arise because the parties aren't really on the same page. So what we see is someone who is, a company trying to cram 5 days worth of work into 4 days. And the employee thought they were really signing up for a true 80% of the job type of deal. So what we often see is that it becomes, 4 15-hour days. Or recently I saw a situation where someone was hired in a sort of managerial type of role. They had young children at home, and they were very specifically looking for something that would be no more than 3 days a week. And they thought they found it. They had an agreement which said you'll be working in the office 3 days a week. I think it was 9 to 5, maybe 9 to 6, something like that. But her assumption was that the other 2 days a week plus the weekend were her time. The employer's assumption was that she would not be in the office on those 2 days, but she'd be available by phone, by email, by text, etc. And it very quickly came to a head, and the parties realized, and I should mention, neither party had legal advice when they entered into this agreement, so they really hadn't papered it properly. And that was the issue we had, is we had to sort of piece together what the agreement was and see if we could put it in writing. And in that case, we were never really able to. But the point is, for the most part, a 4-day work week, 3-day work week, there's no legal issues there. The only challenge might be if you try to cram too much into those days, because certain provinces in Canada have not only limits on the number of hours in a week, but limits on the number of hours in a day. So you need to make sure you're not going over the number of hours in a day. Of course, this only applies to certain types of employees. It doesn't apply to managers, supervisors, professionals. Lawyers, for example, are not covered. You can make us work as many hours as you want. But for the most part, that's the only real thing that's going to come up is, are you having the person work too many hours in a day? The other wrinkle that occasionally arises, and we've had to advise a few clients on this, is if you have someone who works typically, let's say, 3 days a week, Wednesday through Friday, and most, as you know, most statutory holidays in Canada are on Mondays. So what happens to a statutory holiday if the person never works on a Monday? And there are provisions for that in every piece of legislation. So you got to be mindful of things like that, of the hours of work. Other than that, there's no legal issues that arise from the 4-day or any variation on the work week. It's really, the key thing to me is making sure that whatever the agreement is, both parties understand it and it's documented clearly, because often issues arise down the road, and if it's not clear, you're going to end up in some sort of dispute. All right. Well, thanks for that question, Rob. What do we have next?
All right, so this one gets a little bit personal. So it reads, I was in a job interview where they asked me if I had any medical issues or if I had children. Is that legal? And what should I do?
Yeah, that's a great question. Thanks for sending that in. And I'd be curious to know when this happened. And I guess the next question is, were you hired? Is it legal? I mean, it's completely inappropriate. It's exactly what we tell our clients, our employer clients, never to do. You never want to ask about things like religion, age, children, disability, anything protected by human rights legislation. And the reality is, even when you hire the person, there's no reason to ask most of these questions. Even things like age. We always tell our clients, and when I've done my hiring personally, I don't know how old the applicants are. Obviously, I can make somewhat of an educated guess, but I will never ask. And the only reason I'll ask for their date of birth if they're hired is for purposes of benefits and things like that. Otherwise, there's no reason to ask even after the person has the job. So if you were asked these questions during an interview, and if presumably you didn't get the job, it is obviously this inference that might have been a factor in the decision not to hire you, which is exactly what human rights legislation is designed for. We have human rights legislation in every jurisdiction in Canada, which says you cannot be discriminated against on the basis of certain grounds. It doesn't cover every ground. So you can have, discrimination, which discrimination in and of itself is not a bad thing. As I often say to our employer clients, you should be discriminating in favor of the best candidate. You should be discriminating in favor of the candidate who has the best experience or the best education, etc. There's nothing unlawful about that. You can't discriminate on the basis of protected grounds, traditionally disadvantaged grounds like race, ethnicity, disability, children, family status, etc. The challenge, and I should actually add one caveat to that if there is a bona fide occupational requirement, then you can discriminate. So best example is probably firefighters. Most firefighter positions are going to have a certain mobility requirement. So in that case, you may be able to discriminate against someone who has a disability if it impacts their ability to do their job. Putting aside bona fide occupational requirements, which are very hard to prove, by the way, the onus is on the employer to show it is truly bona fide. Putting that aside, the question becomes an issue of proof. So if you were in an interview and you were asked about your medical conditions or your children, and you were then not hired, the inference is that you were not hired because of those. But can you prove it? And one thing to remember here is that this is what our human rights tribunals are designed to address. It's this type of situation. And we have worked with dozens, I guess probably hundreds of individuals who've had situations like that, either in a hiring situation, a termination situation, or an accommodation situation where they're being discriminated against, or they think they're being discriminated against on the basis of protected grounds. It's all going to come down to proof. So first of all, you know what happened in that interview, and the interviewer knows what happened. No one else really does. So every decision that is made in a court, in a tribunal, is based upon the evidence. So first of all, you're going to have to be confident that you can satisfy a tribunal that this is what happened. Bearing in mind, this is not like what we watch on TV. It's not the beyond a reasonable doubt. The standard of proof is a balance of probabilities. In other words, to put it simply, what is more likely than not? There is very rarely a smoking gun in these cases. Unless you can, subpoena your file, and on the application there's a handwritten note that says, do not hire has small children. That's never going to happen. The reality is that you're going to be relying upon circumstantial evidence, which is A, you're going to have to prove they ask you these questions. B, you're going to prove that you weren't hired, which should not be difficult. And then the tribunal or a court is going to be asked to make that inference and say there must have been a connection there. And practically speaking, the onus is now going to shift to the employer to prove that there were other reasons why they didn't hire you. And when we work with employers in these situations, the first thing I'll say is, okay, well, this is the situation. Forget it for a moment whether you ask the person or not these questions. Why didn't you hire them? What's on the file? And if the file says, well, we didn't hire this person because they only had an undergraduate degree and we needed a master's, or they didn't have any relevant industry experience, that's going to be their defense to say the decision not to hire the person had nothing to do with medical condition, nothing to do with the fact they had children. It was based upon their qualifications or the lack of qualifications. And at the end of the day, a tribunal is going to make a decision as to whether they believe them or not. And if they don't believe them, then you'll be entitled to compensation. And generally speaking, for human rights claims like this, there's two types of compensation. There is what we usually call general damages, or damages for injury to your dignity and sense of self-respect, which frankly have been historically nominal in Canada. We're talking about $5,000, $10,000, $15,000. Nothing substantial, but still better than nothing. And the numbers are going up. The other type of compensation is lost wages. So if you can prove that you didn't get the job because of the fact that you had a medical condition or had children, then you can also get lost wages for the wages you would have earned in that job. The same way that if you were fired because you had a medical condition, you can get lost wages in that situation. So there are remedies available to you. And if you truly believe that you were discriminated against, this is one of those situations where, I'll go back to my usual saying, if you think you need an employment lawyer, you probably do. I would definitely see an employment lawyer and get some advice as to whether it's something that's worth pursuing or not. You can't just let it go. If you have that sense that something is wrong, that you were discriminated against, you should definitely pursue that. And that's what human rights legislation is there to address. All right, Rob, what do we have next?
All right. So you were mentioning television, and before we did the show, we were talking about Hawaii. So this one makes me think of Magnum PI. So the question reads, who is entitled to see the results of a workplace investigation?
All right, love the question. I'm not sure how we got to Magnum PI, but anyway.
Because he's a private investigator.
One of the things I was going to say in response to this question is, in our role as counsel, I've done investigations. Our team can do investigations. We usually prefer not to. We usually prefer to be counsel as opposed to investigator, because if you're the investigator, you can't also be the lawyer on the file. So usually we're the ones, in my ideal world, when I'm working with the employer, we're the ones who actually retain the investigator. I've never looked into Magnum PI. I don't know if he's still working these days, but next time I will. But seriously, one of the things that we like to do is we like to be the ones who retain the investigator. It helps to maintain some degree of privilege, which gets to the question of who sees the results. At the end of any investigation, there's got to be a report. And report can mean many different things. I mean, typically when I say report, we think of a fairly lengthy, legalistic type of document, which it will be in many cases. In other cases, it might be a short email, which simply says, I received a complaint of harassment, I met with the complainant, I met with the respondent, and here's what I find. But in most cases, it's more substantive than that. And the way I like to run things is that, as I said, we retain the investigator, whether it's Magnum or someone else. We get the report at the end of the day. And in many cases, we being the team at Rudner Law, we're the only ones who actually see the full report. In many cases, we don't even send it to our client, which surprises a lot of people. But I'll tell you why. In most cases, there's really no reason for people to see it, and there's a lot of reason for people not to see it. So take the case of a sexual harassment investigation. And I've seen this several times now, where there's an allegation of sexual harassment. During the investigation, it becomes clear that there was a consensual sexual relationship, which may have become non-consensual at some point. But this report is filled with details of the romantic and sexual relationship between two coworkers. There's absolutely no reason for their manager, for the owner, for the CEO, for anybody else to see or be aware of those details. What they need to know is what the allegations were, essentially what the process was in the investigation, and most importantly, what were the conclusions? Was there a finding that there was harassment or there wasn't harassment? So at the end of the day, and this is particularly true in Ontario under Bill 132, the complainant has a right to know what the conclusion was. They also have a right to know whether any discipline was imposed. The accused has a right to know what the outcome was. And someone in HR or whoever is sort of guiding this is also going to want to know what the outcome was. So we often prepare a very short summary or executive summary that we send to the parties. But for the most part, we try to keep the full report as close to the chest as we possibly can, knowing that if this goes to litigation, at some point the report, as well as the investigator's file and their notes, may have to come out. But in, I'd say, 95 out of 100 cases, that report stays with us, and the parties see a very short summary of the conclusion, and that's it. And that surprises a lot of people, but I can tell you we have not been challenged on that. And actually, one fairly amusing situation about a year and a half ago now, where we had a client, they weren't a client of ours at the time, they became a client of ours. They had someone who filed a complaint of harassment with the Ministry of Labor in Ontario. Once they got the complaint, the ministry contacted the employer contacted our firm, we retained an investigator, a full investigation was done. In Ontario under Bill 132, and we're seeing this evolve in other jurisdictions as well, including federally, there is an obligation to conduct an appropriate investigation, and the Ministry of Labor basically has the right to evaluate whether the investigation was appropriate. So in this case, our client or our investigator that we retained did the investigation, gave us their report, which was about 15, 20 pages. We sent a one-pager to the complainant, to the accused, and to our client, and to the inspector at the Ministry of Labor. And I then spoke to the inspector and said, this is all when Bill 132 was fairly new. And I said, well, do you have to see the report? And the inspector, to his credit, was quite honest with me and said, I don't know. I'm not sure how this works yet. But he said, I'm going to look into it. And if I need the report, I'll get back to you. That was about a year and a half ago. I haven't heard anything since. So presumably they don't. So the Ministry of Labor seems to be okay with the report being, reserved for counsel unless there's a claim made. So back to the question, who is entitled to see it? No one has to see the complete report, but the complainant, the accused, and if there's more than one complainant or more than one accused, they should know what the conclusions were and if there was some sort of discipline imposed. Other than that, it should be kept as confidential as it possibly can be. How are we doing for time, Rob? I think we got time for one or two more.
So let's do two more. And this question is on discrimination, and I've probably seen at least 6 different varieties of effectively the same question, but I guess pinning it to one specific way that it's been asked is this. What can an employee do when they feel they are being discriminated against? What if an email was sent to the manager, but the response was, it's all in your head?
Yeah, I'm not surprised that we're seeing a lot of questions. I mean, I've said this many times in recent months, and we spend more time at the Human Rights Tribunal than we do in court these days. There are so many allegations of discrimination, of harassment. It really becomes a full-time job for most HR professionals. So what can an employee do? I mean, one thing that we always tell people is document everything. It's one thing to feel as though you're being discriminated against, but usually when you have that gut sense, there's a reason for it. It might be that you're being excluded from meetings that you used to be part of, or that you're being, work is being taken away from you and shifted to someone else, or you're not part of discussions or even into social activities, or there's just a different tone in the workplace. Whatever it is, there's usually a reason for it. Discrimination, by the way, could be different things here. It might mean, this might be more of a bullying situation where it's not based upon a human rights ground. It's not because the person is female or black or Jewish or whatever the case may be. It's not a human rights ground. It's just a matter of the fact that they're being shunned or excluded, which constitutes harassment, which can be a constructive dismissal. So either way, if you are now being shut out of things, then document everything. If it is a human rights issue, if you feel, and we've helped people in many situations where they say, it's very clear that all of the older workers are being pushed out, or all of the women are, none of the women get promotions, all the men do. And we've worked with clients to basically put together a case where it starts with a feeling, and we eventually start putting together documentation to show that, yes, there were 30 people that were, at the level where they might be promoted to management, and 5 were. And all 5 of them were men, whereas the other 25 were women in an extreme case. You're going to have to document something. And again, like I mentioned in a previous question, there's very rarely a smoking gun. And that doesn't matter because this is not a criminal prosecution. It doesn't have to be proof beyond a reasonable doubt. What you need is enough evidence to show that on a balance of probabilities, it's more likely than not that there was discrimination, either based on a human rights ground or just discrimination, which really constitutes bullying, which is also unlawful. Either way, the key is going to be what the evidence is. And if there is enough there to show a case, human rights tribunals and vice chairs are essentially the judges of the tribunals. They've been around long enough to usually be able to see discrimination even when there is no clear evidence. As long as there is sufficient evidence to warrant a finding, then there will be. The flip side of that is we often see people who are convinced that there is unlawful discrimination because they can't accept the fact that they perhaps were not the best candidate. And I've had people come to me and say, I didn't get this job, and I know I was perfectly qualified. So the only reason I can think of is that it was because of my gender, race, ethnicity, etc. And what I'll tell them in that case is, look, unless you've got more to go on than that, you really don't have a case, because it's got to be more than there was a protected ground and the person didn't get the job. If you can prove there's a connection between those two things, that's when there's a breach of the Human Rights Code. Again, though, and this gets back to what I often say, but if you think you might need an employment lawyer, you probably do. If you really have that feeling, and if you can satisfy yourself that it's more than you just being upset that you either didn't get the job or something has changed, go see an employment lawyer. The worst thing that's going to happen is the employment lawyer is going to say, you know what, I don't think it's a viable case. And in that case, at least you'll have the peace of mind of knowing that you actually inquired and got some advice, as opposed to just wondering for the next 1 or 2 or 5 years as to whether you should have done something. So again, how do you know? Usually we know. So trust your gut on these things. All right, I think we said we had time for one more.
So we have one more, and everybody's going to look at this and say, oh, this is a softball question. But I think it's a good question in the sense of red flags. So, you need to be able to know triggers and when to get expertise. So for the question, it's this. How do I know if I should talk to an employment lawyer? Specifically, though, what are the red flags to watch at my job?
All right, so yeah, that does seem like a bit of a softball question, but I think this is really, really important. And it's amazing to me. I've been practicing law for 20 years. It's amazing how often people have that gut feeling that I talked about, in answering the last question. They have that gut feeling that something is wrong, but they don't do anything about it. And they just assume that either the company knows what they're doing or it's all in their head, and they don't do anything to enforce their rights. And the reality is that, I'll say it again, if you think you might need an employment lawyer, you probably do. You should never do anything that's going to compromise your legal rights without getting legal advice. So signing an employment contract, accepting a severance package, accepting a promotion and signing off on some documentation of that. Or if you have a job and you feel as though you're being bullied, we talked a bit about that in one of the previous questions. If you're being harassed, if you feel like you're being discriminated against, if you feel like you're being excluded, or on the flip side, and we've had many people in the last couple of years in the the Me Too or the post Me Too era, we've had a lot of clients who've been accused of sexual harassment, and they know there's an investigation going on, and they have already gone through the interview process. They want to know what their rights are. Again, you should go speak with an employment lawyer to make sure you understand your rights. So again, what are the red flags? I mean, there are far too many to mention now, but it's when things are changing. So I'll start at the beginning of the relationship. You get an offer, you should get it reviewed. The end of the relationship, you get a severance offer, or if there's no severance being offered to you at all, you should go see a lawyer. But during the relationship itself, what are the red flags? Things are changing. Your job is changing. Your reporting relationship is changing. You're not being involved in the same processes, tasks, projects that you used to be. The job or the work that you used to do is now being given to someone else. You are being passed over for promotions where it's clear that you were the right person for the job. Anything like that, you should go see an employment lawyer. Or you're being disciplined for things that everyone else gets away with. So you come in at 9:02 and you're written up, and yet your colleague comes in at 9:15 every morning and is never spoken to. Again, that's a form of discrimination, essentially. You should see a lawyer. You can always start by going to HR, and every company is different. In some companies, that can be effective. In some companies, especially a very small company where the owner is HR, that's not going to get you very far. But if you have concerns, you can start by going to HR. But I would usually recommend that you're going to want to see a lawyer as well. And as I've said a few times, I think today, document everything. So obviously, if there are emails, save them. And remember that there may come a time where you don't have access to your corporate email anymore. So if there are important emails, don't just assume that they're stored in your corporate email. You can access them anytime you want. At some point, you may be cut off. So if there are important ones, forward them to yourself, download them, print them, do whatever you have to do. And then for anything that's not in writing, document it. Make notes to yourself. On April 14th, 2019, I met with so-and-so in the kitchen. I said this, they said that. Document as much detail as you can, even down to things like what they were wearing, because at some point if your credibility is questioned, the more detail you have, as long as it's accurate, the better. So if you can say, not just sometime around the spring I spoke to so-and-so, but on April 12th at the, during the afternoon break in the lunchroom, and she was wearing a red top and black pants, that's going to be even more credible. It's going to make your case even stronger. So document everything. And the best thing, when we have people come to us, I'm going to ask them what they have in terms of documentation and ask them to put together whatever they don't have and get it to me, because I'm going to want to review that. Because reality is people are more persuaded by documents than by verbal evidence. So it's one thing for you to get up and say, this is what happened. It's even better if you have something in writing. And that's just I guess, a quirk of human nature. So document as much as you can, but then also don't let it sit. Now, if you think something is wrong, then go see a lawyer. And oftentimes we'll often have someone come up to us proactively, and I'll say, you know what, I don't think you're there yet. You're not at the point where you could make a claim, but it may go that way. And in that case, we can give you the roadmap essentially as to what you should be doing, A, to protect yourself, but B, to document and gather all the evidence that you're ready to either pursue a claim or to defend yourself if need be. And I'll come back to the situation where people are accused of harassment. We'll have people come into us and ask what they should do because they know they're being investigated. So the first thing we'll say is, look, if you're investigated, tell the truth, but you also need to document everything and make sure that you have the evidence necessary so that if you are, let's say, fired because you are found to have engaged in harassment, you want to be able to defend that allegation if you need be, and perhaps even go on the offensive and file a wrongful dismissal claim. So see a lawyer, document everything is really what it comes down to. And I know we've got to wrap up in a moment, but it's kind of a good segue to one of the points I wanted to make. You look at the questions that we answered today, and Rob, I'm sure you've got many more, and we can go for another hour. And I've done sessions where I've gone to conferences, or I've done sessions for various organizations where it's just an open ask an employment lawyer. And I've done an hour, I've done an hour and a half, I've done 2 hours, and we've never ever run out of questions. The reality is there are tons of questions about employment laws. And it's not surprising because employment laws impact almost every single one of us. Almost all of us are either employers or employees. And what continues to amaze me is that whether it's your business or your career or your job, it's a fundamental part of your life. And yet people probably spend more time trying to choose the right cell phone provider than they do assessing their employment contract. People don't take the time to understand the legal consequences of contracts or anything that happens at work. And in many cases, they'll just kind of brush it off and hope it gets better. And the reality is, it almost never does. So I will say this, and again, it might sound self-serving, it's almost always less expensive to either investigate a concern or prevent a problem than it is to try to fix it later. And we've seen situations where a 5-minute phone call could have saved someone tens of thousands of dollars. For example, you're let go and you're offered a severance package and it's 8 weeks. And you think, well, that sounds about right. So you don't go see an employment lawyer because it might cost you $300 or $400 to get advice. And instead you sign off on the severance package. And later you find out that you should have been entitled to 15 months. And I've seen this happen time and time again. Or on the flip side, you're an employer and you think you have an employment contract that is watertight. So you dismiss someone without going to see an employment lawyer. And instead of being on the hook for, let's say, $5,000 in severance, you're on the hook for $100,000, plus your legal costs, plus your employee's legal costs to have to get it from you. All these things add up really quickly. And if you had been proactive, 5 or 10 minute phone call could probably have saved you or gotten you tens of thousands of dollars. So I guess that's probably all the time we have today. So just to conclude, that was fun. I gotta say, I enjoy these.
That was fun.
Yeah, it's good to have you be more part of the show, Rob. And I think we can do this more often because there's never a shortage of questions. When I'm out and about, either at a conference or at a cocktail party, there's lots of questions. So we can do this probably every few months, I would think.
So to your to your point about not understanding the Magnum PI when we were talking about investigations, so Paul was in the comments in YouTube and he was saying, loved the Magnum approach, but he could never wear or grow that mustache.
I won't even try to. I love that. I love the comments. So yeah, and we often don't get enough. So if you have comments, everyone tuning in, feel free to. It'd be great. If you have questions between now and the next show, or just questions that arise out of what we talked about today, feel free to email us at info@rudnerlaw.ca. I should mention our next episode is going to be Tuesday, September 17th. As always, past episodes can be found on our YouTube channel, on our website, or on our Facebook page. If you like our pages or subscribe to our channels, you get notifications. Also, please sign up for our newsletter. You can always email me or email us at info@rudnerlaw.ca to be added to our newsletter, so you get notifications of not only Fire Away, but all of our upcoming events and also some news, employment law updates, so you can keep up to date. Keep in touch with us throughout the month on our social media. But as I always say, and I've said it several times today, none of this replaces legal advice. So if you think you need an employment lawyer, you probably do. Feel free to reach out to us, and if we can help you, that's great. If we can't, no harm done. But thanks, Rob. You were more active in this one, or at least more in front of the camera than usual. But that was fun. So thanks, Rob. Thanks, Rebecca and Mark, as always, for helping put it all together. Thanks to everyone for tuning in, and I'll see you September 17th.